Townend, Director of the Centre for Law and Information Policy here at the IALS, and I'm delighted tonight to introduce another Judith Bannister, from University of Adelaide, speaking on a very timely subject, freedom of information. Of course, this is our anniversary year in the UK, 10 years since the introduction of the Act, and I just looked up a few stats earlier to inject. In the UK, we've had more than 400,000 requests to central government bodies, and there are now over 100,000 public authorities within the scope of the Act. So it has really sort of widened and grown, obviously, since 10 years ago. So Judith is here visiting the Institute, and I've actually forgotten how long you're here for.
Only 3 months, I've got 1 more month to go.
Yeah. So we're very lucky to have her here. I have sort of shamelessly hijacked her to be part of my centre, even though the centre didn't exist when she first signed up for this. So I'm very glad she's here. Judith is undertaking a comparative study of freedom of information in Australia and the UK using meta requests, which I really like this term. These are FOI requests about FOI requests to research the use of exemptions that protect government policy decisions and deliberative processes. And her central question is confidentiality necessary for collective decision making in government? I won't say too much more about that because Judith's got plenty of time to develop that this evening. Just to tell you a little bit more about her, she's also taught at the University of Western Sydney and Flinders University before joining Adelaide University, and focuses on administrative law and intellectual property. She's combined qualifications in law and librarianship to develop the research in the field of regulation of information access, and integrates FOI, copyright and confidential information in her research. And she has a PhD from the Australian National University in the field of information law. And she has written heaps and heaps of stuff around information and media law, so Google her, look up her profile, and you'll find all her publications. I won't list them all now, it'll take too long. So we've got a wonderful opportunity tonight to really hear a bit about Judith's research in quite a lot of depth. She's going to speak maybe for sort of about up to an hour, and then we'll have some time for discussion and questions afterwards.
I gave a speech about a month ago now, at the beginning when I started my fellowship, and I said the next one that I would present would be an academic equivalent of what I've done on my holidays. It's only been 2 months in, so you'll see I still haven't quite finished as much as I was planning to, and the meta requests will part of the project are ongoing. But that's the nature of freedom of information in any event. So we'll see that it's not the end of the story. Eventually, this will turn up as a what I've promised my university is going to turn up as a journal article. So that'll be the final part of the process. Okay. So any contributions that anyone would like to make at any point, that would be great. Okay. So, as Judith said, and I love that there's another Judith. This is what I'm undertaking is a comparative study of UK and Australian FOI law, but on a particularly narrow point in a way, but one that I think is particularly important. And coming from, you'll see how I've come to this from an Australian perspective. It's concerning the exemption that we call the exemption relating to deliberative documents. We'll have a look in a moment what the UK equivalent of that is, but basically the exemption in freedom of information that concerns formulation of government policy and deliberative processes. To what extent ought they to be exempt from disclosure under FOI? Oops, we're already ahead of ourselves here. Okay. Starting point now, back in a couple of years now, by the time you've got these ideas and then applied for a fellowship and so forth, and you look at it, oh my goodness, it's 2 years since that was a hot issue. Lots of things have happened in Australia at a Commonwealth level. I'll make one point now. I'm particularly talking today about the Commonwealth Freedom of Information legislation. I can take sort of general questions on some of the state and territories. Being a federal system, of course, underneath the Commonwealth Act that I'm going to be talking about, you've got lots of different approaches at a state and territory level as well. And that creates one sort of problem for the comparative process, as you'll see. So a couple of years ago, there was Australia has had about 10 years. We're over 30 years now, so our Act commenced operation December 1982. So old hands, it's getting a bit long in the tooth in relation to certain areas. So numerous reviews. The most recent one at a Commonwealth level was the Hawke review. There were lots of criticisms of this review, that it was not nearly as comprehensive as it might have been, and basically the review suggested that further work needed to be done. With that sort of caveat, I picked up from that review one particular quote that I sort of used as a starting point for this study, which related to Australia's exemption for deliberative documents. And the point that was made was, unlike other conditional exemptions, so in both Australia and here, this is a conditional exemption, it's subject to a public interest test. There's no requirement that the deliberative matter could cause any particular kind of harm. So there's no harm requirement, no prejudice requirement as such. However, having said that, so in that sense, it's, and the same as here in the UK, in that sense it's a class-based exemption, but one that's qualified, that's subject to a public interest exception. The harm that may result from disclosure is, however, relevant to the public interest test. This is where all the arguments are concerned. It's not, there is always the first question about whether or not this is deliberative material, or does this relate to sort of government policy or whatever. But once that part of the exemption is engaged, a lot of the discussion and a lot of the argument arises in relation to the public interest part of the analysis. And what the Hawke review said was the absence of a clear indication of the harm that the exemption is designed to protect results in the exemption being subject to different interpretations, and it's difficult to apply. And I think, sort of reading underneath that, basically, the expectations from public officials about the level of protection that this exemption might give is very different to that of applicants, and the media particularly, but other applicants. And there's this, there's no real clear understanding of what's intended to be protected. So when I do the paper, of course, I'm going to do a little bit of history, and I won't sort of focus on that today, except to emphasise that from an Australian perspective, this has been we've had over 30 years of FOI, and it took 10 years for, and I know here in the UK it took even longer than that, but it took 10 years of debating between 1972, when the then Whitlam government promised to introduce a US-style Freedom of Information Act, in 1972, to the enactment in 1982. And during that time, and some of these reports have been out and around for a while, and others have, interestingly, over 30 years now. Of course, this is all available through the archives. So the answer to any public official is eventually it all comes out, even if it's 30 years later. So there was a whole range of interdepartmental committees where you can see, if you go back into the 70s, how terribly concerned they were all about the idea of FOI and what this might mean in a Westminster system, the idea of imposing a US-style freedom of information onto a Westminster system, and doing it before England had done it. We're normally used to watching England and see how they do these things and then follow suit. So this was terribly troubling. And so there's lots of quotes you can get from these interdepartmental committee reports from back in the 70s. There was great concern over how FOI would impact upon the decision-making processes of government. And the language from over 30 years ago, or more, is still familiar today. So the process of thinking aloud on paper, except it's now electronic, but that occurs in the drafting process cannot but suffer if it has to be conducted in public. So this was a major concern. And basically there was an expectation of confidentiality. So again, this was the 76 Interdepartmental Committee report. In the committee's view, it would seriously hinder the business of government if such matters could not be committed to paper in the expectation that the documents will be kept confidential. So from the very early stages, there was an expectation or a sort of a vain hope that there should be an expectation of confidentiality for deliberative material. However, the exemption, when it was finally passed, was qualified, subject to public interest tests, and so there's no expectation of confidentiality. So in a way, everything I'm going to now said we're going to talk about this for about an hour, and basically the answer to all this is we've had this for over 30 years. For over 30 years, there's been no expectation of confidentiality. Get over it. But of course, it's still a live question in FOI today. The expectation lives on, I think, in claims that are still regularly made about future harm. So disclosure now will cause harm to the decision-making process in the future. So, and from many of you, and we'll find out when we have a bit of discussion where you're all from and whether you've got backgrounds in FOI, but as you no doubt many of you would be aware, public officials argue that if we cannot be guaranteed confidentiality in these deliberative processes, the early stages of policy development and decision making, it will inhibit the free and frank exchange of views in the future. It will limit the range of information supplied to government by third parties. Now that is a key question. It's not one that I'm going to focus on today. In a way, you could do a separate hour on third party sources. And it will deter officials from creating records. I think actually you'd have to say, again, we've had FOI in Australia since 1982 and the archives are full of records, so you have to wonder to what extent FOI has deterred officials from creating records, and that's one of the arguments that is often not accepted by merits review bodies. Now, these kinds of future harm arguments, they're problematic if what you want to be doing, and as we see when we come to look at some of the legal principles, what you're supposed to be doing is making a case-by-case analysis and considering the content of the specific information that's subject to the request. And so there's these two things. There's arguments about future harm do not sit well with the requirement that there be a case-by-case analysis and particular consideration of the content of the information that is being requested. And basically, if you're looking at what's been applied for now, the material exists, it's been documented, third parties have supplied the information if that's relevant, records have been kept, it's there. Unlike my thing. So that doesn't sit very well with an argument of future harm. Okay? So it's not about the information that's before you that's the subject to this request. The argument's being made that if we disclose this, and this could be quite, sort of innocuous information that really could be disclosed, but if you disclose it now, then this is going to put the fear into decision makers in the future, and they will be less prepared to give free and frank exchange, express candid views, write things down. Okay, so you're all familiar. I mean, this is probably nothing new to you. As indeed this case, some of you may know about the recent upper tribunal decision here this year in Britain. But coming from the outside, I like this language. I like this analysis. Now, this is a case, as probably many of you will be aware, relating to an application for access to ministerial diaries. So the harm actually being considered in this instance was a suggestion that public officials would change their behaviour in the way they either set meetings or, sort of beefed up the diary or whatever, that there would be a change in behaviour. So although that's slightly different to some of the other future harm arguments in relation to disclosure of frank and candid advice and so forth, it's still a future harm argument in the sense of a change in behaviour. So the upper tribunal recently has said as such, a risk of harm is based on ministers and officials acting contrary to their better judgment and duties to promote the public interest. The idea is, look, if you really do say you're going to behave in this way, then that's contrary to your obligations and your professional conduct. So, what needs to be asked, and again this is from the Department of Health and the Information Commissioner in Lewis, need to ask how the alleged risk of harm, this suggesting that behaviour will be changed in the future, how this fits with the proper performance of ministers and officials, particularly in relation to the Civil Service Code, whether either of the witnesses, what generally happens, as you're probably no doubt aware, is that you have witnesses who come before the tribunals and say, this is what will happen in the future. And the question is, well, sort of an appropriate question is, well, are you going to behave like that in the future? Will the witnesses and the minister in this instance, are they going to act in this way, change their behaviour in this way? And generally the answer would be, well, no, I wouldn't behave that way, but other people might. And so then the question is, if one would expect that they would say no, that they would not change their behaviour in this way, then why is it said that other people would, and anyone worth their salt would act in this damaging way? Okay. So, what I'm doing in this study, and as you'll see, it's not quite finished yet, but I've been working on it. I look firstly at some legal principles. Just started with that quote in the case, and I'm looking at so rather than this being a sort of a black letter analysis of the courts in the various jurisdictions, I'm looking at low-level merits decisions. So the decisions at first instance of the public authorities and Information Commissioner decisions. So looking at merits-based analysis of this. The legal principles, I'll start off with tribunal decisions. So Information Commissioner decisions and the meta requests that Judith mentioned before is what I've done, and I've now discovered I need to do a bit more of, is sort FOI requests to get decision letters in FOI cases. And I'll show you how I've done that. Okay, so for comparative purposes, what we're looking at here is comparing Section 35 in the UK Act, which relates to the formulation of government policy, and Section 47C, which is obviously a differently worded exemption, but it's similar in principle under the Australian Commonwealth Act, relating to exemptions for deliberative processes. So one, you're looking at information that relates to the formulation and development of government policies in Australia. The language is one of deliberative matter for the purposes of deliberative processes. Nevertheless, they're both conditional, subject to a public interest test, and there's no harm element there. So in that sense, at least to initially be engaged, it's a class-based approach. Is it or is it not, relating to the formation of government policy? Is it or is it not deliberative matter? There's no harm element in that, but there is a public interest analysis. Now, there's some important differences that you need to understand, and it's made the comparison a little bit complex in this process because, one good thing that could certainly be said about the UK Act is there's far fewer absolute exemptions. Australia has more absolute exemptions where there is no public interest test, and the big one that has an impact in how I come to compare these cases is that we have a class-based absolute exemption for cabinet documents. So there's arguments around the edges about what is and isn't a cabinet document, and over the years it's been amended to try and reduce the range of documents that fall in with that, and there's sort of satirical jokes about people wheeling trolley loads of documents around the cabinet room in order to benefit from the exemption, which doesn't quite work because it has to be created for the purposes of submission to cabinet and so forth. But nevertheless, a major difference in Australia is that we have this absolute class-based exemption that's not subject to a public interest test. So I've got to take out the cabinet documents if we're going to do any sort of comparison here. And also, the one I've sort of become stuck with a little bit is also in relation to legal advice. There's also an absolute exemption in relation to the legal professional privilege in Australia. You take out the legal advice and take out the cabinet material. Another major difference relates to the process of merits review. Now, in the UK, when a merits review body, and I know I have someone here, but I'm happy to be picked up at any point on on any of this. I'll just say, oh, look, I'm an Australian, please tell me. But the relevant date when you're a merits review body, information commissioner or tribunal in the UK, and again, this is probably familiar to you, is you look back to the relevant date. So you're looking back to the date that was relevant when the public authority was first making the decision, or the internal review decision. So that's the key date. Okay? So way back in the process. Whereas in Australia, merits review is involving an external review body, information commissioner or tribunal. When I was here last time, I briefly mentioned the woes of Australians' information commissioner. Still ongoing. I'll leave that if anyone's interested to the Q&A afterwards. So at the moment we can still talk about a Commonwealth level information commissioner, but in any event, there are at some state levels there are commissioners and also the tribunal. Nevertheless, what we've got is merits review, full merits review at where the relevant date from the merits review body's decision point of view is the date of their decision. So the key point here, of course, is that the merits review body can take into account events that have happened since, and obviously when we're looking at these kind of deliberative materials, it's the time, by the time it gets to the review body, it may no longer be a live issue. Time has passed. So the passing of time is an important factor here, and so the dates of when these decisions, the relevant dates for these decisions is an important difference in this process. For the UK, the merits review bodies are looking back and asking, did the public authority get it right? Which I suspect must be slightly frustrating, because you sort of think, oh, well, they might have got it right at the time because it was a live issue then, but, 10 months on, it's looking rather different. Australia, the merits review body is asking, is this exempt material now? Okay? So I've just, as I've pointed out, we can take into account recent event. That She and migration, that's a CLO, is a High Court, Australian High Court case. It's about migration agents registration authority, not about FOI, but the principle is established in that. So you can take all the relevant information into account that's happened since the time the original decision maker was made. So it may be that the public authority did get the decision right at the time, but now time's passed, things moved on, and a different decision can be made. This has an impact on how the government agency argue the safe space argument, which is the language of the exemptions here in the UK. Now, as I briefly alluded to, we've had all sorts of major problems with the Australian Information Commissioner. Now, this is not in any way to criticise the Commissioner or in any way represent stats on outcomes, because all I've got here is a very small sample of cases involving the deliberative materials. So I don't want this to in any way reflect criticism. You need to understand the time frames involved here. So not only in the UK are you looking back to the date of the public authority made the decision, but actually all the time it's all happening a lot quicker here. So don't want to turn this into a criticism of the delays, but there is absolutely no doubt that one of the problems with the Information Commissioner was the delays in the decision-making process. And the longest one in this study, as you see there, was nearly 4 years. And for a lot of the UK Information Commissioners, this was all turning around in about 10 months, which looks remarkable from where I'm standing, although it might seem very, very slow from your perspective, okay? So you need to keep in mind those sort of time frames are here. So by the time it does get to merits review, a lot of things could have happened from the Australian perspective. So, I said I'd look at a couple of legal principles. Now, I don't know my audience, so I'm not sure if this is going to be old hat or whatever, but from an Australian perspective, I find these information tribunal decisions very interesting. I would like to pick up some of this authority and transport it back home if possible. So in a case that is regularly cited, and now I've just realised department here, help me out, Department for Education, what's the S? Skills. What is it? Skills, thank you. There
It was science.
Science, right, very good. Look, I feel better that the room's like that. When I looked at that, I thought that was dumb to put up an acronym. So I knew it was education anyway. So regularly cited case of what was the Information Tribunal in our first year tribunal, as you all know. 11 principles that are regularly cited, and you can see this coming up in the decisions of the Information Commissioner and in fact in the decision letters of the agencies. Sometimes you'll see references to, sort of there being no, well, we'll see as we go through them, but so elements of this are turning up even if not cited in the decision letters as well. So 11 principles. The central question is the content of the particular information in question, which is why I think these claims of future harm are so problematic. No information is exempt simply because of its classification, nor advice to a minister, nor seniority. You'll see some of these are the opposite to the Howard factors that we were dealing with in Australia for many years. The purpose of confidentiality, if there is any, is not to protect ministers, but in some instances civil servants. And you'll see that the tribunal in this case was particularly concerned about the extent to which you named civil servants, and particularly lower level civil servants, which seems perfectly reasonable. This is the important one of the major ones. That's my star, not the tribunal star. The timing of the request is of paramount importance to the decision. Disclosure of discussions of policy options while the policy is in process is highly unlikely to be in the public interest. Now, this links in to, for those who were here for my first lecture, this links into the argument the more theoretical argument I was making there about questioning whether or not what FOI is, one of the underlying rationales for FOI, whether that's participation in the decision-making process or accountability for the actions of government. And my argument was it's about accountability after the event. So that can accommodate a safe space during the time of formulation of policy. So, and this principle clearly accepts that it's often going to be the case if you've got a live issue, if the departments are in the middle of this, then there's going to be a strong public interest against disclosure at that time. So ministers and officials are entitled to time and space to hammer out policy without the threat of lurid headlines. So I would have said intervention, but let's bring the media in here without the lurid headlines depicting it. And basically meddling with the process, interfering in the process, okay? Now, but it's very time sensitive, and it doesn't say anything about accountability for that process once it's complete. So when, as always, the key question, and I'm seeing this coming out in some of the Commissioner's decisions and particularly the Commissioner's decisions, the question is, how long does this last for? Whether or not it's over and the extent to which agencies might want to argue, oh, it's still live, we're still thinking about this, we're still developing this. You know, one of the cases where this might be going to judicial review, those kinds of arguments stretch this out. So, and that's always just going to be a question of fact in each instance. This is an interesting one. If the information request is not in the public domain, the fact that other material relating to it has been published doesn't necessarily mean, it's not going to set a precedent. It doesn't mean that this information that's still unpublished should be disclosed. So I'll try that again, see if that made any sense. So even though there's other material out there about this controversy or whatever, that in itself is not necessarily a reason why the information that's being sought ought to be disclosed. So it's not a significant factor when working out whether or not there's a public interest in disclosure. I think you can flip this. Sometimes agencies argue, oh, there's lots of information out there about this, therefore you don't need these emails. Okay, which is sort of the flip of this argument. I think there's a problem with that as well, because FOI ultimately is about compelled disclosure. It's about the ability to go to government and say, tell me about this. And any amount of voluntarily disclosed information doesn't necessarily undermine the argument for FOI disclosure. So the public domain argument, the fact that there's information out there, I think works both ways. We're expected to expect courage, independence of civil servants, but there's maybe good reasons why junior civil servants ought not to be named. I think that's undoubtedly right. And often with these things, what's really required is the information itself, to know about the issue, whose name on the bottom. It's a collective decision. It's a collective decision of government. Whose name is on the bottom of the letter is not necessarily, if you black that out, it's not necessarily going to undermine the accountability process. Also, we're in town to expect politicians don't take it out on officials if something comes out in the FOI process. That seems perfectly reasonable. Decisions should not assume the worst of the public. We'll see some of these issues in what's referred to as the Howard factors in Australia. And again, we're back to, there was a great concern here with the names of junior civil servants, which I thought was interesting. But some of the other issues are key principles. And for our purposes, for the material that's being, the deliberative material that's being considered here, there are really two key principles. The timing of the request, is it live? And the content of the requested information. And both of those are equally important. And it's the content of the requested information, I think, is ultimately the interesting one. Safe space argument is strongest when the issue is still live, and then you have interesting questions about whether it is live. The public authorities seek to extend this. It's in the implementation phase. It's a very recent province. They want to stretch out this process, and that's balanced against the nature of the content of the information. Okay, so some important principles from the tribunal. It's a matter of applying them. That's the interesting point. Contrast that with, now, I have to say the shadow of Howard, because if I had other Australians, FOI people here, they'd say, oh, everyone agrees that the Howard factors are dead, except they're not. So, way back, 1985, I get to wallow around in the 80s. I like the 80s. I'll age myself here. So, back when we were all dressing really badly and listening to interesting music, FOI was young. And Mr. Howard, John Howard, who was for many years Prime Minister, but back then was in what we call Liberal coalition, and Conservative coalition was in opposition, Labor was in government. Howard was after documents about negotiations between the Labor government and the ACTU, the unions. So that's what it was about. And in that case, there was a series of factors that were listed that became the bane of FOI applicants for many years. The Howard factors were cited routinely in decision letters, and they were queried, as you'll see, I haven't listed all the authorities here, queried many times by tribunals, very sceptical about it, but nevertheless the Howard factors were relied upon by agencies for many, many years. And in fact, as we'll see in a moment, in 2010 at a Commonwealth level, there was changes to the legislation to sort of get rid of some of these factors. And it's old, it's the 85, and in many instances it's the complete opposite to what's being said by the UK tribunal in the earlier slide. So some of these things, you can see how this really stifled FOI from an Australian perspective back then. So the higher the office of the person between whom the communications pass, and the more sensitive the issues, the more likely it shouldn't be disclosed. So, you know, if it's a terribly senior person, then that was a public interest arguments against disclosure. These things will, for those of you who are FOI advocates, I don't know, if you're from government, you probably think, oh, this sounds good to me, but if you're for FOI advocates, then these things are problematic. Now, disclosure of communications made in the course of development and subsequent promulgation of policy tends not to be in the public interest. The problem with that is there's no time frame. There's no suggestion that while it was live, that was an issue, but just generally material in the course of development of policy. This is the one that's lingered on. Disclosure which will inhibit frankness and candour in future pre-decisional communications is likely, disclosure of that is likely to be contrary to the public interest. Frankness and candour haunts us still. And some of these were just have been dismissed for years, but they were routinely argued. It will lead to confusion and unnecessary public debate. The public won't understand it, they'll be confused. And these were accepted as public interest arguments against disclosure. They might, again, give the wrong impression of the decision-making process. They may not fairly disclose the reasons. The answer to these two, of course, is more disclosure. Okay, well, if you think this is going to confuse people or you think this doesn't properly represent it, disclose more, provide reasons, expand rather than disclose. So I haven't put all the authorities up here, but they've been criticised at many levels, tribunals and so forth. And over the years, external review bodies have been reluctant to accept these Howard fact arguments, certainly without any specific evidence apart. So they basically said, look, prove it. Okay. In 2010, the Act was reformed and specific, some of the Howard factors were specifically excluded or cited as irrelevant factors. So the fact that it might embarrass the government or cause loss of confidence in the government, that wasn't one of the factors, but it was other arguments that had been made. That's completely irrelevant. Access to the document could result in the person misinterpreting or misunderstanding it, this idea that it would confuse people. Again, and basically for many years people have been saying this underestimates the public's ability to understand, or at least the ability of experts to explain this material to the public. So that is an irrelevant factor. Who the author of the document is, this is clearly aimed at one of the Howard factors. So if they're of high seniority, that's completely irrelevant. And again, the access to the document could result in confusion or unnecessary debate, completely irrelevant. What's not there is the frank and candour argument. So it's potentially still arguable. Now, the Information Commissioner's guidelines was, and I have to put these up, the material up here, but guidelines expressed doubt about that and said that the frank and candour, the future harm argument, is not in the spirit of the Reformed Act, although as we'll see, there's been some Information Commissioner decisions which don't quite follow that line. In Australia, there's also a temporal element. I should have probably had this a bit earlier in the slides. So there's a presumption of disclosure and it's subject to a public interest test. unless in the circumstances access to the document at that time. So if access at that time would be public interest. And again, that's problematic for an argument for future harm. Okay, yeah, I'm thinking of my hour here. This is particularly Australian, and for those, I'll leave the slide up there so if anybody is interested in this thing, but we've had a series of Information Commissioner decisions, and again, this is not sort of having a go at the Information Commissioner in any way, but it's because it's the context of particular material, but where frank and honest advice arguments were accepted. Now, it was in relation to incoming government briefs. And I think what we need to do in Australia is actually distinguish this down to the nature of the material. There might be something special about incoming government briefs. Again, I think this is a bit too Australian focused for the audience, but you might argue, as in fact the Hawke review did, that there is an argument why you don't want FOI access to the red books and blue books, the books that are prepared by the public servants for incoming ministers, they're ready, depending on whether it's going to be Labor or coalition. Although, interestingly, I don't know how they would have done it here with this election that you've just had if you've got no idea who's coming in. I'm not sure how the incoming government briefs would have worked here. Anyway, so there may well be arguments why disclosure of those would be problematic. The problem is that there's been a sort of an acceptance in these cases of a future harm argument, which is fine if you approach this from the context of the particular information. The problem that you had with Howard factors is it just became a standard routine way of arguing it without looking at the context, without looking at the particular information involved. Okay, so I've got about 15 minutes to talk about. That's all right because I haven't finished this. So what I've done is I've looked at Information Commissioner decisions with the joys of the keyword search. So the language is slightly different, but the concepts are similar. In the UK, you favour this concept of safe space, also frank and candid, chilling effect, and the safe space argument, which is one that's particularly interesting in the study, is during this live policy development process. In Australia, I think influenced by Howard, it's all about frank and candid rather than, we don't have so much language around the safe space argument, but it's the same kind of principle. I wanted to reiterate that, but I think I made that point before. The fact that you're looking at live safe spaces now, and we're looking at other arguments about future harm, a lot of that's to do about the decision-making time frame there, I think. Okay. So also when I was looking at these Information Commissioner cases, I had to get rid of the cabinet papers. So a lot of your Section 35 cases relate to cabinet documents, which doesn't make a lot of sense from our point of view because they're just all out of it anyway. Legal advice, and again, the absolute exemption for legal. And I know you have a separate conditional exemption for legal professional privilege, so I tried to get out the legal advice and the cabinet papers. And I didn't look at Section 36, which is prejudice to effective conduct of public affairs, which is this second exemption, which applies to other public authorities. That's not just confined to central bodies. And there's a harm element. That's just not comparable from the Australian perspective. There's no Australian equivalent to that. And in fact, this idea of what applies to local authority is we're in a federal system. So local authorities and so forth are covered by state and territory legislation. So for that reason, I didn't compare the Section 36 exemptions either. So I ended up, this is why I've still got a bit of work to do here. I've got to expand it because I ended up, in 2014, 26 cases in the UK was fine. The 7 cases for Australia was a bit slim, and it was slightly distorted by the incoming brief, a couple of incoming government brief decisions. So I'm going to have to expand this out into other years. But that was the comparison. Now, this is what I I'm mucking around, and anyone who's got any ideas about where I'm going to go with all this, I'd be very grateful. But I've been looking at it from the point of view of the time frame of the requests. So, and from the UK, the Information Commissioner's perspective, if you looked at cases, far more cases as you might imagine for the reasons I've already been mentioning, a lot of the cases, the time frame was such that it was still ongoing, certainly at the relevant date, and in many instances still ongoing even at the time the Information Commissioner was looking at it. So when you're looking at that, the fact, so there's 13 cases where it was upheld because it was a live issue. The surprising thing that there were 5 cases where it was an ongoing, a live request, and yet the Section 35 exemption wasn't upheld. And this is where the second element, the looking at the nature of the information, came into play. So if the information was mostly factual or innocuous, then even though it was a live issue, it wasn't going to succeed on this on a safe space sort of argument. On another case, it was still, the Commissioner accepted it was live in the sense that there were still some ongoing issues, but it had been going on, 2 of them, that had been going on a very long time. One of them, as I mentioned, there was the prospect of judicial review, but really it had been going on for a very long time. And another, although the government had been dragging its heels basically, it had plenty of time to actually act on this, and they hadn't done, and they hadn't explained why they hadn't done, and there was no real explanation about why disclosure at this stage would have caused harm. So you've got 5 cases there where the nature of the information and the time frame was looked at specifically, and the exemption was refused. From Australia's point of view, even though you're looking, so when I looked at that time frame earlier, you might think, oh, by the time it gets to the Information Commissioner, they should be letting all this stuff out. Time's passed, the relevant time is the date of the Information Commissioner's decision, but actually the exemptions were still being upheld. So I'm going to sort of sit down with some of those and do a bit more comparison on that, because it's not, the outcomes are not what you might expect given the differences in the merits review process. Okay, so that's part of the study. Happy to take questions on this afterwards. The other part is the meta request part. So I've actually then gone one step back into the process and looked at public authority, government agencies we'd say, but public authority decision notices. Okay. One step before the Information Commissioner's decisions. That's just some stats there. You can't do any comparisons here for all the reasons I've just explained before about the nature of the difference between Section 35 and 47C, the fact that we're only talking about a federal level in Australia, and so the numbers aren't really, you can't do anything with these stats particularly, except to make the point. And in a way, it might actually you might ask yourself, why am I bothering to even agonise over all this when the percentage of exemptions claimed are tiny. These government policies, the deliberative documents, exemptions are relied upon in very few cases actually. As you all probably all no doubt aware, the big exemption, the one regularly relied upon, is private information, personal information. So the numbers are quite small. I have no idea. I mean, this is interesting, and I think I don't know if at some point I'm going to have to drill down and work out why that was, but why it's gone down in UK, I don't know. Not from looking at the particular decision letters, but basically all that tells you is that it's relatively small numbers. But what I was able to do with these small numbers, so that was from the annual reports. What I was able to do from those small numbers is drill down, because of the wonderful world of open data. We had this conversation before. And I suspect, again, the Australian Information Commissioner is, the Commonwealth Government's trying to get rid of the position at the moment. And so for a brief shining moment, they were just publishing open data sets. I do worry that we might 2014 set, which was I haven't got here, but might be the last set. So I think I'm going to have to act quickly before this all disappears. But with open data, this is the data behind the annual reports. So what I was able to do was to go in and find out which agencies were the major users of these exemptions. And the open data is also available here in the UK as well. So, and as you see there, some of them are comparable. Health, in both instances, Attorney Generals, Cabinet Office, Prime Minister and Cabinet. All I've done so far, so this is only a month since I saw you all last, so all I've done so far is the Attorney General's Department, and it needs more work. But basically, what I've found, and this is what I was saying to you before, you're going to have to go beyond this, and hopefully it'll become clearer in some of the other agencies, because for a lot of the Attorney General's cases, the reliance was simply on legal advice, or cabinet confidentiality, neither of which really worked comparatively for Australia. So I'm going to have to go on and look at other agencies and see if I can find something a bit more useful. From an Australian perspective, it's interesting at this level, the agencies are relying upon the argument that deliberations are still in progress. By the time it gets to the Information Commission, the argument seems to have changed, and then it's about future harm. But at this point, the deliberations in progress is a regularly relied upon argument along with the future harm excuse as well. So, the other thing, and this will come as no surprise to anyone, but this is just to show you that I did actually get all the decision notices. And there is a tendency, this is no surprise here, there is a tendency for them to often look, how can I put this? What did I say? I wasn't going to say boilerplate, was I? They start to look very familiar. Attorney Generals in Australia seems to like this phrase very, very much. So it's the same argument over and over again, including the argument that there may relate to deliberation, future harm to the deliberative process. So really, and this won't come as a surprise to me, I still want to know what reasons are being given at this level, because not everything gets to the Information Commissioner level, but really the detailed analysis of the material doesn't really happen at that first decision letter stage. The detailed analysis of the content of the information either doesn't ever happen and people just walk away and think, oh well, didn't get that, or it's done at the Information Commissioner level or into the tribunal.